Good evening, everyone. Welcome to Empower You tonight. Glad you could join us. I know there's lots going on in the city of Cincinnati tonight. We've got the big debate between Aftab and Steve Shabbat, which should be a lot of fun. Is that on TV? Anybody know? Or they had one, I missed it. I was out of town for a couple of weeks. And anybody see any of the debates so far? Lou, did you see any? Anybody see one? Who won? Shabbat won. Anybody else feel a little bit differently about it? Or, well, I hope I can go home and maybe watch a little bit of that tonight. So we're glad to see you tonight and welcome you to Empower You. We're about 2/3 through our semester. We've got some great classes I want to tell you about. And most of all, glad you could join our free university. And we do try to keep it free for most of the classes. There's a couple classes we charge a little money for, but if you can, help us out with the donation jar when it goes around, because that helps us keep giving you free classes. So let me tell you about a few of the classes that are coming up. For business guys like me, Thursday night we've got a good one, Understanding Financial Statements. If you're in business, if you've got a son or a daughter that's a new manager that's looking to get ahead in the corporate world, we've got a very talented Glendale guy, CPA, Jeff Babiak, who will be here. And he'll be talking to you about how you should look at a financial statement, how it can help you make decisions on running and growing a business. And I think it'll be really interesting. We've been trying to find somebody to do the class for a long time, and we're going to be doing it Thursday night. So selfishly, I hope you guys will consider coming to the class I'm going to be doing, which is going to be next Thursday night. We won't have a class Tuesday because what's Tuesday? It's going to be election day. But next Thursday night, we're going to do a class that's kind of near and dear to my heart, and it's a class that will be remembering the great Charles Krauthammer. It's going to be a fun class. Now, if you think you're going to come, though, and just sit back and watch a few video clips and smile, you're wrong. Because I'm going to work you. I'm going to work you really hard next Thursday night. And what I'm going to ask you to do is I'm going to ask you to reset your beliefs of what you believe in. And I'm going to let you hear Charles walk you through all the great issues of our day. Things like healthcare, things like immigration, things like the wall, things like, gosh, I've got 100 things. I can't believe I'm forgetting about them. Things like gun control, affirmative action, climate change. Charles was really known as the great defender of the Reagan doctrine. He'll put Ronald Reagan into, he'll give you kind of his analysis on where Ronald Reagan fits in the great historic figures of our time. He'll also talk to you about Richard Nixon. He'll also talk to you about Donald Trump, somebody who he's never been a big fan of. And mostly what I'm going to ask you to do next Thursday night is come in the door with your thoughts and see if Charles, in his great conservative thinking, can sway you, can change you, can cause you to move. And it'll be a fun class, and most of the class will be in his own words. Not a lot. The good news is not a lot from me. So that's next Thursday night. I hope you'll come. After that, we've got a great class the following Tuesday, November 13th, the history of the Roebling Suspension Bridge. That is going to be a really interesting one, and I know that we've got somebody who will be here that night whose mother, I think, she'll write a letter she found about the Roebling Bridge being built. That'll be interesting for you. And then on November 15th, my friend Michael Patton will talk to us about the electrical grid and what would happen if the electrical grid went down. So conspiracy theorists like me, this is your opportunity. And then on November 19th, we will have an evening with Abraham Lincoln as we celebrate the exact 155th celebration of Lincoln's Gettysburg Address. The evening will start out with, I think just an incredible, well, he's a look-alike who's done this forever, and he did one 5 years ago for us on the 150th celebration. He was incredible. The program he gave that night, the quips he told about Lincoln, how he dressed in character, how he talked in character, was something that if you've got kids of any age, I really encourage you to bring them that night. This is a program that will stand the test of time. It'll be a great night. So we hope to see you at that event also. So tonight, just to kind of entice you into coming next Thursday night for my presentation on Charles Krauthammer, we're going to give away his book to one of you. So Betty, do you have the names? So get your tickets out. And let's go for number 458. 458. Who's our lucky winner? 458. Uh-oh. We'll try again. How about 46? Oh, sorry. So let's give Jude a round of applause. So this book, have any of you ever read it? Okay, so it's really, I've had so much fun going through it. It's from his time as a columnist for the Washington Post, where he won a Pulitzer Prize. There's probably 100 essays, which are 3 pages, where he writes about everything from the use of the F word to his love of baseball and chess, and really lots of interesting things. So Jude, I hope you enjoy this. And with that said, I want to introduce you to the team who kind of helped me a lot while I was gone the last couple of weeks. Bill Roll, our treasurer, in the back. Let's give him a round of applause. We've got Betty Overstreet, who's our community relations director. We've got Joe Platt, who's our board member right here. And we've got Jay, who's our producer right in the back. And hello to everybody online. We're glad to have you here tonight. So with that being said, I want to introduce you to Betty, who's going to introduce our speaker. Thanks for coming tonight.
Thank you, Dan. Matt Byrne primarily represents clients in state and federal trial court and appellate litigation in arbitration and before administrative agencies. His litigation experience includes the full spectrum of employment matters, ranging from individual claims to complex class and collective actions. He has represented clients in appeals before the Ohio Supreme Court and the United States Court of Appeals for the Sixth Circuit, among other appellate courts. Mr. Byrne also counsels employers regarding a wide range of employment-related issues. He works with employers in a wide range of industries, including financial services, automotive, healthcare, information technology, manufacturing, and nonprofit, including churches. Please give a warm welcome to Matt Byrne.
Well, thank you, Betty and Dan, and thank you all of you for coming. I hope this will be an interesting discussion for you. Excuse me. In addition to my work at my firm as an attorney, I also head up the Cincinnati Lawyers chapter of the Federalist Society, an organization that you may have heard of. We'll talk about it a little bit tonight, but I always like to clarify when I do things like this that I'm not officially speaking for the Federalist Society tonight. So why are we here? I think it's ultimately because everybody in this room has an interest in what happens to our courts. Certainly, surveys show that that's true of voters, particularly in the 2016 election. One well-cited CNN poll found that about 20% of all voters said that their vote for president was significantly impacted by how they thought that candidate for president would deal with judicial appointments. And among those voters, 56% of them voted for Trump rather than for Hillary Clinton. Those numbers are higher, as far as I understand, than in the past with other presidential elections, showing that voters have become particularly engaged in figuring out what exactly are these candidates going to do when it comes to appointing people to serve on the federal courts. The court system, it's almost a truism, but it has a great impact on all of our lives. Whether we're somebody who has a will issue, or you have a family member who's got a criminal matter, or you work for an employer who has large civil litigation, or you're just a citizen who's concerned about courts making decisions that create new law separate and independent from what may be in the Constitution or in statute. So we all have a stake in our court system. It's one of the 3 branches of government at the federal level, but at the state level too. And it can, I think, to most people, maybe is sometimes the hardest to understand. How do these judges get where they are? How do they decide cases? What is it that the courts really do that impacts us? And so what I want to do is talk about, first, to kind of set the stage for all of us. We hear in the media a lot about the Supreme Court. I think all of us, I'm guessing, we're probably hanging on the Kavanaugh confirmation process and seeing what happened with that, which was stepped up a notch even from what we had gone through with the Gorsuch nomination process. We hear some things in the press about the circuit courts of appeals, but you really don't hear a lot about the district courts. And we'll get into what the differences are between those courts in a minute. But my broad point is, we need people to, I think, be more informed about these different courts. And that's what I'm going to try to do tonight, to give you a little bit of insight into where we are and where we're going. But first, let me kind of set the stage, because it's really basic, but I think it's hopefully helpful. I know when I started law school, I was already interested in the law. I'd read a lot of law, but frankly, when I started law school, I didn't quite understand exactly how these different courts fit together and what their names mean. So let's, excuse me, just go over that real quick. We really have 2 separate, broadly speaking, 2 separate court systems in the country: the federal courts and the state courts. And they, in some ways, mirror each other in structure, but they actually serve different functions. I'll start with the state courts. And then, of course, there are differences from state to state. So I'm not going over all 50 states, but I'll talk about here in Ohio. How is the court system set up, and how is it maybe different than the federal system? So at the state level, we first have trial courts. And in Ohio, we have a number of different trial courts. The one that I think is most well known is the Court of Common Pleas. It's your county general jurisdiction trial court. Common pleas courts hear criminal felonies, civil cases involving $15,000 or more, cases involving title to real estate, not things like evictions, though, we'll get to that later, and some appeals from some administrative agencies. So most of the time when you watch the news and the local news says, Judge X or jury Y has decided this in this criminal case or this important local case, it's usually talking about the Court of Common Pleas. And I should also, before I go on, explain, in Ohio, all judges are elected. They can be appointed by the governor if there's a vacancy, but we have of course, an elected judiciary in Ohio where judges serve for 6-year terms, which of course is different than the federal system that we'll get to. But the Common Pleas Court isn't the only court, well, at least the Common Pleas General Division. There's also specialty segments of the Common Pleas Court. There's the Domestic Relations Court, which deals with divorce, annulment, child support, visitation rights, things of that nature. The Probate Court, which deals with wills, adoptions, issues marriage licenses, etc. Also fiduciary matters. And the Juvenile Court, which deals with juvenile crimes, but also child support, child abuse issues, neglect, things of that nature. So these kind of specialty courts that I just mentioned, probate, juvenile, and domestic relations, are actually part of the broader Common Pleas Court. Then we also have what's called municipal courts or county courts, depending on which county you're in and where you are in the county. Here in Hamilton County, you have a series of several municipal courts, or at least municipal court seats. In Warren County, where I live, we have both a municipal court and a county court, but they're essentially the same thing. They deal with civil matters involving up to $15,000 in claims, and less serious criminal matters. They would also deal with probable cause when you're talking about the initial stages of a felony matter. But it's a lot of things like landlord-renter law, evictions, more serious traffic citations, things of that nature are dealt with by your municipal court judges. There's also mayor's courts in Ohio, where if you're in a village or a city, there will be a magistrate who deals with really kind of low-level criminal matters, things like building code violations if they're criminal in nature, certain traffic violations, animal control, things of that nature. And we have an Ohio Court of Claims, which is a trial court for claims against the state, or in some cases for recovery of compensation by victims of crimes. That's a lot of courts, but that's the lowest level of the trial courts in the state. They all, and I should also mention the municipal courts have a small claims division where really low dollar value matters can be handled in a very informal way. In Ohio, you see up there in the blue, we have the trial courts. Appeals are made to the District Court of Appeals. There's, I believe it's 12 districts in the state of Ohio. Most of them are multi-county. Here in Hamilton County, you're in the 1st district, which is just Hamilton County. If you go a little north, if you're in Warren or Butler, like me, we're in the 12th district. It includes 8 counties that kind of ring Cincinnati and Dayton. But the courts of appeals in Ohio, they, of course, it's in the name, they deal with appeals from the trial courts. They also handle some matters as an original jurisdiction. So there's a few things where you actually start in the Court of Appeals instead of in the trial court. Those are pretty limited, things like habeas corpus and cases involving disputes about who holds a public office, things of that nature. And then appeals proceed from the District Courts of Appeal to the Ohio Supreme Court, which is the highest judicial authority in the state, has 7 members. It's, as with all the Ohio courts, elected. We have 2 seats open this year. One thing that I think a lot of people don't understand is, and I want to clarify because it's a little bit related to what we're going to talk about, what happens when you get to the Ohio Supreme Court? Is that always the end of the road? The answer is usually yes, because most matters that make their way up through the state courts and get to the Ohio Supreme Court are state law matters. And on state law matters, state Supreme Courts are the final authority. If the Ohio Supreme Court says this is what the Ohio Constitution means, or this is what this Ohio statute means, that's it, that's what it means, at least as legal matter. However, if we have a system where claims that are federal, and some state claims too, actually, it gets kind of complicated, they can actually be brought in both federal and state court. There's lots of procedural rules that determine whether you can go to one or the other, or whether you've got an option. But sometimes you'll have a case that involves federal issues that's litigated up through the Ohio court system, and you get to the Ohio Supreme Court. To the extent that there's a federal issue, that can actually be appealed from the Ohio Supreme Court, essentially to the United States Supreme Court. So if, for example, the Ohio Supreme Court made a decision on the meaning of the takings clause under the U.S. Constitution, and the parties didn't feel like they got it right, they could appeal that to the U.S. Supreme Court. Now, separately, we have the federal courts. And the federal courts are spread throughout the country. They're not just in D.C. Every state has a federal court, at least one in that state. And the terms are a little different, which can get a little confusing. So in the federal courts, which are authorized by statute, but ultimately, by the United States Constitution, we have, first at the trial level, we have district courts. So again, just to point out possible confusion of terms, in Ohio, a district court is an appellate court. In federal court, a district court is the lowest court. It's the trial court. The district courts hear original matters. There's a lot of different ways you can end up in a federal district court, but usually it involves either a federal question, so you've got a claim brought under a federal statute or under the United States Constitution. Like in my case, I practice employment law, so many of our cases end up in federal court because people sue under Title VII of the Civil Rights Act of 1964 or under the Age Discrimination and Employment Act. Those are federal statutes. But you can also end up in federal court if you've got diversity, meaning maybe it's one of those state law cases that you would think the Court of Common Pleas would handle, but if you've got two factors, you can go to federal court. If the amount in controversy is more than $75,000, or and more than 75, and there's diversity of citizenship. So one of the parties is from Ohio, one is from Kentucky, and it's more than 75,000, you can go to federal court. There's a few other ways you can get in federal court, like if it's a purely federal matter, bankruptcy, copyright law, those types of things. In Ohio, and we'll come back to details in a minute, but in Ohio, we have two federal district courts, the United States District Court for the Northern District of Ohio and the United States District Court for the Southern District of Ohio. And the Southern District encompasses Cincinnati, it's based here in Cincinnati, and all of Southern Ohio up to and including Columbus. But there are actually three courthouses. There's one in Cincinnati, one in Dayton, and one in Columbus. And so we have federal judges in each of those cities. Here in Cincinnati, we have, I think it's currently three, actually some of them are retired, but basically 3 seats. We'll come back to them in a minute. Appeals from the district courts and federal court go to the circuit courts of appeals. Ohio is part of the 6th Circuit, includes Ohio, Michigan, Tennessee, and Kentucky. The most famous circuit court of appeals that I think everybody knows about is the 9th Circuit. That includes California, Arizona, Hawaii, Michigan, what am I saying? Washington, Oregon, and a couple other states. So when you think about the 9th Circuit, here we're not in the 9th, we're in the 6th. And these are really, really important appellate seats. Each of these appellate courts have a certain number of appellate judges. And just like in the state system, in the federal system, when you have an appeal, the case is not tried again. I think that's one common misperception. Sometimes people think that you have a trial in the trial court and then a party loses and they appeals and then you have another trial in the circuit court. That's not how it works. You only get essentially one shot at your trial. You have your trial or your key decision in your trial court, the district court, and when it goes to the Court of Appeals, the cases are heard on briefs. Each party submits a brief saying what the trial court got wrong or got right, and then they usually have oral arguments. And those cases are all decided not by one judge, but by panels of 3 judges, where a 2-to-1 vote carries the day among those judges. They issue written opinions. And there is a fair amount of coverage of these circuit court seats. You might have seen some news coverage about the 6th Circuit candidates, who we'll get to in a few minutes. And then a case can be appealed from the circuit court to the United States Supreme Court. And I think we're all familiar with the United States Supreme Court, really the final word on federal legal issues. And the key difference between the federal courts and the state courts, beyond just how they're structured, is how judges are selected, which is really why we're here. In the federal court, the Constitution says that an Article 3 judge, that's the relevant section of the Constitution, is nominated by the president for appointment, but confirmed by the Senate, and then serves for life. The lifetime appointment, of course, creates a very different dynamic than the elections with 6-year terms that we have, at least in Ohio. There's something you should know about for life as we move forward. These seats, by statute, there's something that Congress did many years ago where they created something called senior status. So, if you're a federal judge and you're appointed for life, once you reach a certain number of years combined with a certain number of years of age combined with a certain number of years of service on the court, you have the option of taking senior status, which is kind of like being a retired judge, but you still get to hear cases as long as you want. So they actually vacate their constitutional Article 3 seat, but continue to serve as a judge as they want, and somebody else can be appointed to fill that vacancy. So for example, here in, I'll do the Sixth Circuit. Here in the Sixth Circuit, we have, I always forget, I believe it's 16 Article 3 constitutional seats for judges. But we have about 8 or 9, I forget the exact number now, 8 to 10 senior judges who also sit on the Sixth Circuit, and they can continue to hear cases with their non-retired colleagues. Let me move on. So what are we looking at in terms of numbers, just to set the broad playing field right now? When President Trump came into office, we had a record number of vacancies in the federal courts. Of course, everybody knew about the US Supreme Court vacancy caused by the death of Justice Antonin Scalia, but there were a number of many Circuit Court of Appeals and District Court vacancies as well. There hadn't been a lot of confirmations near the end of Obama's presidency. You had a lot of retirements, and frankly, once President Trump took office, you had a lot of judges who had been appointed by Republican presidents who decided now was a good time to take senior status. And I didn't put it on the slide. I think it was somewhere, I think it's actually around where it is now, 150, 170 or so vacancies. It was a lot of seats to fill. So what's happened so far in the nearly 2 years of the Trump presidency? Well, as you know, we've had 2 seats of 9 filled on the US Supreme Court with Justices Gorsuch and Kavanaugh. On the Circuit Courts of Appeals, the president has nominated and the Senate has confirmed 29 Circuit Court judges. Of the total 168 Article 3 positions that are available, which is a significant number. That's 17% of all Circuit Court of Appeals judges in just 2 years. These are the next most important judicial seats in the country after the US Supreme Court, and 20% have been nominated by this president. And that number is certain to go higher. On the district, actually, I should say, it'll go higher, but maybe not at the current rate. The president and the Senate have really focused on filling the highest seats first. So we've got a lot of the Circuit Court vacancies filled. There's still some left, and there's really a lot of work that needs to be done on the district courts. So far, the president's nominated and the Senate has confirmed 53 trial court, federal district court judges out of 548 positions, which is a lower 9% of the district court seats. But critically, we still have 154 either current vacancies or known vacancies. They're a little different because if a judge says, I retire today, that's vacant. But a lot of what happens is a judge will say, I'm going to take senior status next May. So they start working on filling that position, but the seat's not quite empty yet. But 154 of those seats that can be filled, 15 remain on the Circuit Courts of Appeals, and 139 remain on the district courts, the courts that deal with the vast majority of cases decided in the federal court system. Right now, there are 72 nominees for judicial spots pending in the Senate. Some of those have been already recommended by the Judiciary Committee, and they're waiting for a full Senate vote. Some of them have gone through a hearing in the Judiciary Committee, but the committee hasn't voted yet. Some of them are just waiting for their hearing. So they're all at different stages. We've got 72 of them, hoping to be confirmed sometime soon. 12 Circuit Court of Appeals nominees and 60 District Court nominees. A lot of seats. So the question is, how are these people selected? When it comes to the US Supreme Court, it's a pretty, I think, widely known, fairly transparent process. The president really has discretion to choose who it is that he wants to nominate for those seats. The president, of course, whoever the president is, will consult with many people, many different organizations, and you have a lot of input into that process. And something that happened in this presidency that's never really happened before, as I think you know, is President Trump, when he was still a candidate, announced a list of people he would choose from. Nobody's ever done that before. The list was publicly stated, largely developed by the Federalist Society and some input from the Heritage Foundation too. And I think if we look back, it's worth remembering that there was really a reason why he did that. I mean, he was, I think we all know who President Trump is now, but at the time he was there was a question mark, and he had made some statements early in the campaign about thinking that if he's looking at who he'd put on the Supreme Court, it'd be somebody like his sister, who is a liberal judge on the Third Circuit, a Bill Clinton nominee. And there was questions about, well, who is he really going to appoint? And he put out this list and said he would appoint people from that list, which I'm not a pundit, but I think it influenced a lot of people to know who he was thinking of, or at least willing to think of for those seats. That list has actually been revised twice. The list that came out during the campaign is not the list we're dealing with now. There were 2 supplements. The third supplement, which came out last year, included Brett Kavanaugh. He was not in the original list. So I don't think I need to say a lot about that process, except that there's some good conservative organizations and good people in the White House who deal with these nominations, who are advising on those choices. I should explain, because it's relevant to the other courts we're going to talk about. The president, and I worked at the Bush White House dealing with nominations, not court nominations, but dealing with all other nominations. The president doesn't sit there and get on Google and say, who am I going to nominate? There are people who work on these things and figure out who to recommend, and they make their recommendations to the president, and the president says yes or no. When it comes to judges, those people are the lawyers who work in the White House counsel's office. The White House counsel is, the chief lawyer for the president, not for the president personally, but for the office of the president. And the way they structure it, at least in this White House counsel's office, is the associate counsels have regions. They, within those regions, they work with people and groups to come up with the names to recommend to the president, which will be really important in a few minutes. So that's how the Supreme Court's dealt with. There's no surprises there. But what about the Circuit Courts of Appeals? It's a little different, because we're talking about a smaller court that includes just a few states. The Ninth Circuit has the most states, but some are pretty small with only 3 or 4 states, like the Sixth. In those states, I might jump ahead to a future slide, but that's okay. There's kind of a tradition that the president or the people who work for him will consult with people in those states on who should be nominated to those seats. And in particular, we'll consult with the senators from each of the states in that circuit, whether they're from the president's party or not. Traditionally, there has been a process known as the blue slip process. And I'll come back to it in a minute, but I just want to mention it does come into play, or did come into play, with regard to the Circuit Courts of Appeals. So the president will, maybe I should explain blue slip now. The way the blue slip process has worked in the past is there's this senatorial courtesy, where if the president nominated somebody, if you're a senator and the president nominated somebody from your home state, either to be a judge or from some other non-judicial seat, that name goes to the senators from that state. And the relevant committee, when we're talking about judges, we're talking about the Judiciary Committee, the relevant committee will not act until the home state senator fills out literally a blue slip of paper, it is blue, not yellow, and says essentially, yeah, I give the go-ahead for this person from my state to get a hearing. They turn that into the committee, and then the committee moves forward with a hearing. Excuse me. Traditionally, that process was, excuse me, thank you. My apologies. Traditionally, that blue slip process applied to the Circuit Courts of Appeals and to the district courts. So let's just do a hypothetical situation. Let's say there were a vacancy in the Sixth Circuit, again, covering Ohio, Michigan, Kentucky, and Tennessee. Well, let's say Sherrod Brown, or we'll move away from Ohio, we'll go to Michigan, Debbie Stabenow, Senator Stabenow, who's a Democrat. Let's say she didn't like somebody the president was considering for the Sixth Circuit. She just wouldn't return the blue slip. So all of those senators from those states had a big say in who got to be nominated for the courts of appeals. However, things have changed. Early on in this Congress, Senator Grassley, who chairs the Judiciary Committee, and Senator McConnell, who not only is majority leader, but takes a huge interest in the reformation of the judicial branch, they announced early on that they were no longer going to honor blue slips for the circuit courts of appeals. But while the White House still consults with home state senators, it's a consultation. It's not a veto where Debbie Stabenow can say, no, we're not going to get this person. And the idea is that, well, this is a multi-state court. Why should the senator from one state be able to stop somebody for all these other states? And that has resulted in a real difference in who we're getting as nominees for the circuit courts of appeals. But we'll get back to that in a minute. The district courts, the trial courts at the federal level, blue slips remain in place. That process has not changed. It is still the case that this senatorial courtesy exists where if you're Debbie Stabenow in Michigan, or you're Sherrod Brown in Ohio, or Rob Portman, and the White House says they're nominating Joe Smith for the, let's say in this case, the Ohio District Court, those senators can effectively block that nominee by not returning the blue slip. So that means that the White House, the president, has to give a lot more deference to the home state senators when deciding who to nominate, because they don't have the discretion. The president doesn't have the discretion he has with, say, the U.S. Supreme Court or the circuit courts. Well, what happens? How does this work in practice? And it's different from state to state. In some states, the home state senators take a really strong interest in who's going to fill these seats, and they say, "This is my recommendation," and they personally have somebody in mind or a couple people in mind, and they tell the White House, "Here's who we think it should be," and the White House will generally, choose from that list. In other cases, the senators come up with different practices. In Ohio, back when we had Senator Voinovich and Senator Sherrod Brown, they decided that because they were members of two different parties, they would form a joint bipartisan commission. And that commission process has remained in place since the mid-2000s. So each time there's a federal court vacancy in Ohio, now, of course, it's Portman and Brown, but so Portman and Brown will both come up with a list of commission members, and the senator who's from the same party as the president will get one or two more seats than the others. They have a majority, though the rules don't necessarily operate on a majority basis. But they will each nominate a slate. These are usually, generally lawyers who practice before federal courts or professors or things like that. And that commission will review applicants. Then they make recommendations to the senators, and the senators make recommendations to the White House, which again can result in a different pool of people than if the senator is just choosing. In Ohio, as I said, we have a commission process. In Kentucky, Senators McConnell and Paul kind of work this out amongst themselves without involving a commission. The fact that we have these different processes in place to find nominees in different states results in some surprises. You've probably heard news coverage about how President Trump is shaping the federal courts, moving them in a right-leaning direction. You're getting more originalists and textualists. There's lots of scare articles about, oh my gosh, the Federalist Society's selecting people. But it's not that cut and dry. Sometimes political realities come into play, and you get some nominees who you wouldn't expect. Well, it is true that I think we've got outstanding nominees from this president to the Circuit Courts of Appeals. Some would surprise you. There was a nominee to the Ninth Circuit. President Trump nominated someone to the Ninth Circuit from Hawaii who was a former Democrat Attorney General of the state of Hawaii, kind of known to be a liberal attorney, Democrats were thrilled with his nomination, and 27 Republican senators voted against his nomination, but he was a Trump nominee. So likewise, at the district court level, especially in states where you have 2 Democrat senators, there has to be a lot of give and take between the White House and their thinking about legislation and who's going to vote for what. And so you see them sometimes have district court nominees who don't fit the media narrative, who may be a prominent Democrat lawyer in whatever state may be nominated by the president. So these behind the scenes processes really impact who the president chooses. What about Ohio, which is really, I think, what everybody here is the most interested in? So the Sixth Circuit, again, just one step below the US Supreme Court, has had a lot of vacancies since President Trump took office. And not only was the president's first Court of Appeals nominee from the Sixth, Judge Amul Thapar, but he has actually already filled 4 seats of 16 on the Sixth Circuit. And there are 2 more seats that are vacant. So far, John Bush from Louisville, Joan Larson from Michigan, John Nalbandian from here in Cincinnati, and Amul Thapar, just from over the river in Kentucky, have all filled and been confirmed by the Senate these Court of Appeals seats. These are, in my opinion, great nominees who really take the role of a judge seriously, who understand their job is to say what the law is rather than what it should be, who are thinkers, who really get into the weeds. And the Court of Appeals is a really kind of, it's a heady job. It's not a fly by the seat of your pants job like some trial court. Yes.
Question. On that Sixth Circuit Court of Appeals with 16 judges, now do all 16 listen to every case, or are they divided into banks of?
They do not hear every case. Every case has at least a panel of 3 judges, and those panels change from case to case. So when the Sixth is, and they live in their home states, and they fly into Cincinnati or drive into Cincinnati when the court is hearing cases, which is, I think it's 6 or 7 weeks a year. And you may in the morning have, case 1 has judges A, B, and C. Case 2 has A, B, and D, and it just changes throughout the day. And these groupings are constantly changing. But there is an option where if one of those panels makes a decision, the party that wants to appeal has the choice to, instead of going straight to the US Supreme Court, they can ask the Sixth Circuit for something called en banc review, which means that all 16 would sit together and hear that case. Those are fairly rare. It only happens a few times a year, but it is a possibility.
So if 6 to 7 people, 6 to 7 weeks a year, do these people do other things for their livelihoods, or is that their full-time job?
That's their full-time job. And the reason, it's not that they're not working the other weeks of the year, it's just that oral argument's a really small part of what these judges are doing. I mean, each of these cases, if you've got an appellate case in the Sixth Circuit, at least from what's going to happen is the lawyer's going to prepare their briefs. These briefs are, 40, 50, 60 pages long each. There's the party that's appealing files a brief, then the other party files a response, then the first party files their reply. That's 3 briefs. You're well over 100 pages of documentation. And then there's the trial record, which may be hundreds or thousands of pages of documents. Then they have an oral argument if they think it's appropriate. They don't have to have an oral argument. Oral arguments are actually pretty short. In The Sixth Circuit, it can vary, but they're usually 15 minutes. In the U.S. Supreme Court, I think they it does vary, but most of the time you're talking an hour. Then the judges go back and they sit in a room and they decide, okay, what are we going to do? And then they kind of reach an informal conclusion on what the general contours of their opinion will be and who's going to vote which way. And then they go write the opinion. And that can take months of writing and going back and forth with district drafts, with different drafts. So what happens is oral argument's just a tiny, tiny portion of the work that they do. It's really a job of reading and writing in a room with nobody else there. It's a substantial amount of work, even though they're only here in Cincinnati a few weeks a year. So these judges the four I mentioned are currently confirmed to the court. There are two who are nominated and waiting for confirmation. Senator Sherrod Brown, these two are from Ohio, and Senator Sherrod Brown has said he opposes both of them, which is causing a delay. We'll see what happens. But Chad Riedler is for most of his career, he was a litigator at Jones Day in Columbus. Currently, he's I always get his title wrong. I think it's the Principal Deputy Assistant Attorney General. I believe he's very high up actually within the Department of Justice right now. And then Eric Murphy is currently the state Solicitor General in Mike DeWine's Attorney General office. So as the state solicitor's job is to be the attorney for the state who handles appellate matters. So he represents the state of Ohio in the Sixth Circuit, in the U.S. Supreme Court, et cetera. And these are they're great people, they're great nominees, they're great lawyers. We'll see what happens to them. But if they get confirmed, there will be 6 of the 16 confirmed in about 2 years. Excuse me. Now, I mentioned earlier, we have the Northern District of Ohio. The president's nominated one judge to the Northern District of Ohio. Her name's Pamela Barker. She's a judge on the Common Pleas State Court in Cuyahoga County. Here in the Southern District, where all of us, I assume, live, we have, that should say 4 vacancies. The president's nominated 2 of those seats. One is Judge Matthew McFarland, who's on the State Court of Appeals in the 4th District of Ohio, which is basically Portsmouth. And then the other is Sarah Morrison, who is John Kasich's Director of Bureau of Workers' Compensation. The other 2 seats one is vacant because Judge Susan DeLotte took senior status. The other will be vacant soon because Judge Michael Barrett has announced his intent to take senior status. Those seats have not been filled, but we'll see what happens with them. Now, what takes so long? I already went through the blue slip process, but there's a couple of other things that impact how long it takes to get a judge confirmed. One of those is the 30-hour debate rule. The Senate says, or the minority party can request that a nominee be debated for a full 30 hours in the Senate before confirmation. And if you do that for multiple people, it just slows things down. So that can add to the delay in getting people confirmed. Also, they can request roll call votes, so all the senators have to physically come into the Senate chamber and vote, which takes a while. And these things can really extend the process. It's important to know that because I think a lot of people, after the filibuster was eliminated, thought, okay, we'll just nominate, confirm, you're done. Nominate, confirm, you're done. But it doesn't work that way. The filibuster's gone, which plays a huge role in influencing who the president can nominate. I think it's important to keep in mind, Harry Reid got rid of the filibuster during President Obama's time in office, and it, of course, remains gone now. That's a whole new world, and sometimes there's comparisons that are made to what may have happened under President George W. Bush or President Clinton, but they were in a different world where they were dealing with filibuster for these judges, and it's had a big impact on who can be nominated for these seats and who is nominated. So who is nominated? Actually, I'll back up. there's really a different pool of people that you're talking about when you're talking about the circuit courts of appeals and the district courts. These are, when I said something about shoot from the hip earlier, there's a joke that is often told in legal circles, which isn't quite true, but I'm sure I'm going to butcher it. But basically, it's this joke about like a bunch of judges going duck hunting, and the state Supreme Court justice shoots at the duck and says something about, I wonder how what rule can I come up with about hunting ducks? And the Court of Appeals judge tries to shoot the duck and says something like, well, I got to figure out if we're complying with the state Supreme Court's rule about how we hunt ducks. And the punchline is that the trial court judge shoots at the duck and says, I wonder if that was a duck, which for lawyers is really funny, but for normal people probably isn't. But it's kind of flippant, but it is true. I mean, these courts are performing different functions, and so you get different types of people with different backgrounds nominated to these courts. And you can really see it in President Trump's nominees. But it's not just the different requirements of the position. It's, of course, also that what I talked about earlier, that we have, for the circuit courts, he's really not consulting the senators as much as he is on the district courts. You'll see that because the work, well, as I said, the work of these judges is fundamentally different. Trial court judges are dealing with motions and holding hearings and holding trials, whereas appellate court judges, as I said, they're doing a lot of reading and writing. Under President Trump, it's been interesting. The majority of his nominees to the courts of appeals have no prior judicial experience. Only about 38% as of August had been judges before, because I think the reason for that is, the criteria that the White House has really been looking at is judicial philosophy, not necessarily like, have you been a judge for 10 years, but rather, how do you decide cases? What does your background tell me about how you're going to interpret the Constitution, about what you think your role is as a judge, et cetera. So it results in, we're really drawing from two different pools. We're not quite ready for questions yet, so that is the next slide. What we've seen is that, at least at the circuit court level under President Trump, there's a couple themes that you can look at with his nominees that have an impact on where those courts are going. First, a lot of these judges have, or potential judges, have experience or have talked about or written about their thoughts on the administrative state. This was much discussed during Justice Gorsuch's confirmation process, and some with Kavanaugh's till it turned to other issues. But there's really been a lot of focus in the conservative legal world over the last few years about the executive branch agencies and the discretion that they have to come up with regulations. A number of decades ago, there was a case called Chevron that dealt with this question. And the idea is that, Congress doesn't and can't come up with every single little rule that may need to be applied under a given statute. So Congress delegates some of its authority to the executive branch, and the executive branch then comes up with regulations. But if the question for courts is, well, how much delegation is okay? Some of it's okay. I mean, I think we all agree that, the specifics of what type of tools need to be used when nuclear power plants dealing with waste disposal probably isn't within Congress's capacity or their expertise. That sort of thing can kind of be decided by regulators. But what happens when an agency looks at a statute that's phrased broadly or maybe just a little ambiguously and says, aha, we see that what this really means is that we have the authority to come up with this 10,000 page set of regulations. Is that really permissible, or is that the executive branch making law and taking on the role that Congress is supposed to have as the legislative power. So there's been this debate about this Supreme Court case I mentioned, Chevron, which develops a test for figuring out when are these agencies going too far and when are they acting within their delegated power and acting properly. And it seems to me that a lot of the discussion about this, and we've got a lot of nominees who have written on this issue before, and this is just tea leaf reading, I guess, but what we may see as a result, the topic of this was what's President Trump doing to the courts? I think we may see a real moment where the federal courts re-examine these issues of exactly how far these executive branch agencies can go in rulemaking. And we may see more federal courts that are willing to re-examine the amount of leash that's been given to these executive branch agencies. But really, ultimately, what happens with that's really going to be decided by the U.S. Supreme Court. If the case I mentioned, Chevron, if they modify Chevron's test or they get rid of Chevron, we could really see the circuit courts and the district courts coming up with a whole new model for dealing with regulations. The other theme that we see, particularly at the circuit court level, is that you have a number of judges who've been confirmed or nominated who have written about or talked about their interest in textualism and originalism. And I came here to talk to all of you about a year or two ago, I forget what exactly, about Justice Scalia, and he's the most prominent proponent of at least textualism, but he was an originalist too. The idea behind textualism being that when a court looks at a law, it should interpret what that statute means based on its text, what the words actually say, not based on the intent of the drafter. And originalism being essentially the constitutional version of textualism. Originalism is the idea that when courts examine the United States Constitution, it should be interpreted based on its original, usually most conservatives now agree, based on its original meaning at the time that the words of the Constitution were adopted. So we have a lot of judges who've taken interest in these issues, who have records on these issues, and what you may see is a bit of a shift in the courts as they become more textualist or more originalist in the future. I think it's important to note that textualism and originalism, while they are based on these ideas that sound old, we're going to look at what the text originally meant when it was written. It's actually a somewhat new legal movement. In the early part of the century in the legal world, really kind of these progressive, early 20th century progressive ideas had a lot of sway. And you had a number of decades where, at least broadly speaking, you had courts that were interested in making law. You look at the Burger Court and Warren Court, where you maybe had a bunch of Republican nominees on those courts that were just fine with innovation, we'll put it that way. And there was really a legal movement starting in late 70s, early 80s, where people, voices in the wilderness said, no, we need to look at the original meaning and the original text. And now, 30 years, 40 years later, what we're seeing is that movement is having a more significant impact on the courts than it's maybe ever had before. One other thing that I want to mention, because I think it's important as we figure out, well, where's this all going to go, is we have a new White House counsel. Don McGahn has been the president's White House counsel, or was the White House counsel, for the first 2 years, and he left office just a couple of weeks ago. There's somebody in that position right now on an interim basis, and very soon the new occupant will, we presume, he's been named by the president, will fill the position. His name is, well, I'm going to butcher it because I've never actually heard it pronounced, but Pat Cipollone, who's a litigator in DC, complex litigation at a law firm, and has worked in the Justice Department during the George H.W. Bush presidency, he'll be taking over. And so it's just a question mark. I don't know where things will go, but you have to assume that when somebody new is in charge of the vetting process, there may be new priorities, new points of emphasis, new criteria that they're looking at. Some of it may be the same, some may be different, but it'll be interesting to see how the president's nominations change, if at all, under this new White House council. So that's the broad overview of what's happening with the federal courts under President Trump. I'm happy to take your questions if you have any.
Questions right here.
Paul, this is a departure, but you mentioned when you worked in the White House for how long?
I was there a little bit less than a year.
And just roughly how many more lawyers were there?
Well, I was not a lawyer when I worked there. I worked at the White House before I went to law school. But you're asking about counsel's office?
Yes.
Counsel's office itself, it varies from president to president, but I would say it's about 20 at the most, 10 to 20, depending on who's president and what stage you're at in the presidency. But it's a good number, but it's not huge.
How are they paid, or where does the money come?
They're federal employees. Yeah. And there's a whole group of attorneys that really the president has control over, his White House counsel attorneys, but then there's also, of course, senior leaders in the Department of Justice, attorneys who are general counsel at, say, the Department of HHS or Veterans Affairs. You have certain offices within the Department of Justice that are really important, like the office I'm blanking out on the name, but I know it. There's an office that deals with kind of really important federal litigation questions. There's the Solicitor General, who the president appoints to represent the country before the Supreme Court. There's all of these different organizations play a role in shaping any given president's legal policy outcomes.
I've got a question for you. So I think a lot of us heard on the news today that Trump is talking about this whole thing about babies being born citizens of the United States. So if that goes on a legal track, what court is that kind of likely to steer through?
Well, so I had a busy day. I only read the headlines. So my understanding is that he said he was going to issue an executive order. Is that right?
Correct.
Let's say he does that. What would happen, he wouldn't go to court. Rather, people who were impacted by that executive order would then file a lawsuit. And that could and would probably be filed in any district court in the country. It could be somebody who was impacted by the decision who lives in Maine would file in the District of Maine, and somebody in Cincinnati who was affected would file in the Southern District of Ohio. So it could work its way up from anywhere in the country, and it could go through any of those circuit courts of appeals before getting to the Supreme Court. In fact, what would probably happen is with such a sweeping executive order as that, I would suspect you'd have cases almost everywhere in the country. And they'd all be working themselves up through the system at the same time. And the question would just be, which one is going to get to the Supreme Court first?
Who's got a question for
There's one up here in the front.
Who's got a question for
This gentleman up
Oh,
here.
I'm sorry.
My name is Bob Knopp. On the Sixth Circuit Court of Appeals, when those 3 judges are selected, who picks those 3 judges?
The court has an internal administrative system that assigns the judges to cases. And it's not, they don't publicize exactly how that process works, but there's an administrative mechanism. It's the same thing at like Court of Common Pleas. If the prosecution brings a lawsuit against somebody for murder in Hamilton County, which judge does it go to? Well, the court has an internal mechanism where they have an assignment commissioner, and the assignment commissioner assigns a particular judge to hear that case, the circuit courts have something similar that determines how the judges sit. But it's not a public process where like one judge says, you know, I'm going to choose you three and I'm going to choose you three. It's an administrative procedure.
Yeah, I thought maybe some of those judges could say they would like to hear that case. Is that?
They may be able to, I think, express some general preferences, but whether those are honored or not depends on the court. I'm not aware of any court where a judge would say, I want that case. I think, you know, you sometimes see patterns where you can see that, you know, Judge Smith gets a lot of commercial cases, but those are not formal.
Okay, we do have a question from one of our online viewers. The question is, where do the Attorney General and Assistant Attorney General fit into federal legal structure?
So the Attorney General is the Cabinet Secretary who is, even though he doesn't have the title Secretary, but he's essentially the Secretary in charge of the Department of Justice, one of the key federal departments in the executive branch. So the Attorney General is nominated by the President and confirmed by the Senate, and is the Chief Executive Officer of the Department of Justice. And then under the Attorney General, there's a Deputy Attorney General who handles day-to-day management of the Department of Justice. And there's a number of, I couldn't possibly remember them all, but there's a number of other presidentially nominated and Senate confirmed people under the Attorney General. There's a Assistant Attorney General, there's Principal Deputy Assistant Attorney General. There's a number of these. There's probably, in DOJ, I forget the numbers now. I would have known 14 years ago, but there's probably 30 of those versions of the sub-attorney generals. And they each have different either agencies under their control or areas of responsibility. But they all serve at the president's, at what's called the pleasure of the president.
On your slides, on your presentation, you showed and you mentioned that several judges have been nominated, several have yet to be voted upon. As we're approaching roughly 2 years in the current president's term of office, my question would be, compared to previous presidents, regardless of their political party, as we are approaching 2 years into their first term, if you will, is the number, to me that seemed to be a very, when I'm pointing there, I meant your previous slides.
Mm-hmm.
It seems to be a very small number. I mean, a huge number of vacancies, a very small number in many positions of current vacancies and no votes. So is this historical at this point in time for 2 years? For example, the previous presidents, were many of them quickly nominated, confirmed, voted upon?
Right. It's, I haven't checked the exact statistics this month. I know as of a few months ago, if I remember correctly, they were, compared to other presidents, we were ahead of schedule with Circuit Court of Appeals nominees, but behind schedule with district court nominees. And that may have changed with Senate action over the last couple of months. I would not say that it is wildly divergent or that it is particularly shocking that there's that many. I mean, he came into office with a huge number of vacancies. A lot have been filled, but a lot of new vacancies have come up. And that's, you got to remember that you've always got rolling new vacancies. I mean, I mentioned that we've got 4 in the Southern District of Ohio. Judge Barrett announced his intent to take senior status maybe a month ago or 2. I mean, so it was a new vacancy, and it adds to the pile of work to be done. And you always have that happening. So that number, I don't think will ever get down to 0, though that would be amazing. I should also mention that it's not just the Senate that potentially causes a delay. It's also that all of these federal judges do have to go through a full FBI background investigation. So and that's going to happen before the Senate takes any action. So that can take a number of months. I mean, they're very, very in-depth investigations where they're talking to dozens, if not hundreds of people about nominees, and it just takes a long time.
Do very many of them not pass the background check?
I don't know what the breakdown is.
Here's a question.
You mentioned that it's unusual that a judge would request a case. What about recusing themselves?
Yeah, judges don't, and I was speaking broadly about like all courts, but judges don't say, you know, I want X case. Recusal is, you know, a commonly used procedure. If they have an interest in a case, they can and should recuse themselves and say, you know, I know this party, you know, this is my uncle, or I'm a majority shareholder in, you know, this business, or whatever reason it might be. All courts have procedures in place for how a judge goes about recusing themselves. And I'm certain there are statistics that the federal court system keeps. I don't know if the state court keeps those or not. I think we do. I think they do. But it's not something that happens. It's not something a judge is doing every day. And I think you have to keep in mind that the standard for recusal is fairly high. I mean, just because a judge knows a lawyer, that's not a reason to recuse them. I mean, a judge who sits on a bench for 30 years is going to know hundreds of lawyers. Or just because, you know, you maybe know a party, that may not be a reason for recusal. It may just be, you know, this is an acquaintance, this is somebody I've known. I mean, it really is a very fact-specific determination of whether a judge should recuse themselves or not.
Hi, I'm Carolyn, and I wondered, when you were talking about senior status, does that mean that they're still eligible to be hearing cases?
Yes. Yes. So once they take senior status, they'll just continue to work in their same chambers in their same courtroom. But they have a little bit more leeway over how much they work. You know, they could say, you know, I really want to be mostly retired, so I'm going to take, you know, 5 cases this year. Or they could say, I'm taking senior status, but I don't want to slow down at all, and I'll keep up my exact same caseload. They've got a lot of discretion, but the key thing is that they have vacated that constitutional seat, and it can be filled by somebody else.
So are these positions paid for life then? Is that?
Yeah, they can remain a senior status judge for life. They also have the option of resigning, which is very rare. I mean, most judges, federal judges, you know, they'll eventually take senior status and their caseload will kind of decline over time, but few of them ever say, I'm completely done.
Matt, we have an online question.
We have an online viewer who is wondering, what is the purpose of so-called senior status?
Well, I mean, it's a form of semi-retirement. It allows also the court to have extra capacity because, you know, if you only had, say here in the Southern District of Ohio, if you only had the 3 Article 3 seats filled, I mean, they would have to handle all the cases. But because we have senior status judges, they can share the caseload, and some of them work quite a lot. You know, Judge Lott's still hearing a lot of cases. But it's also, I actually don't know historically, you know, what maybe motivated Congress when they first came up with the statute allowing for senior status. I suspect it may have had something to do with trying to open up seats, but it's actually a historical question I've never looked into. But practically speaking, it does serve a, you know, kind of a useful purpose now.
Matt, the district court judges are life appointments?
Yes.
Okay,
Their lifetime.
So I ran into this situation a few years back. I've only filed a couple lawsuits in my life, but I found myself in front of one of these judges you've mentioned tonight, and the judge was a real duck. It was a copyright case, and I got into a situation where the judge said, we don't care what the case is, I want you to settle it, and I'm going to prolong me hearing the case as many years as it takes you to settle it, and you're never going to come into my courtroom. And I think so many of us feel like a lot of these judges are so entitled Is there anything that we can do in a case like that to get away from that judge or to do anything about it?
I don't know specifically about your case, but I mean, a couple things. One, judges do have a lot of discretion. I mean, that's why these positions are so important. They can and do make procedural decisions in cases which can really impact the parties. There is a procedure where you can seat what's called a writ of mandamus from a court of appeals, where a party goes to the Court of Appeals to ask them to require the trial judge to do something, whether it's to rule on a motion or hold a trial or whatever it may be. That procedure is available, but it's pretty limited. In terms of getting away from a judge, as you phrased it, that's pretty rare. Occasionally, there are situations where a party will move to get the judge removed from the case, arguing that they have become biased in some way. But that judge gets to rule on that motion. So a party that wants to move to a different judge has to think long and hard about whether they want to tell that judge, you're so biased, you have to remove yourself. But it's fairly limited. Yeah, I mean,
and I think we the people have to decide if we want these judges to have life appointments. Do you have any thoughts on that?
I get that lifetime appointments have some drawbacks, but they also have a lot of positives about them too. I mean, the federal court judges who are lifetime appointed, they do have a separation from politics. I mean, they don't have to worry about who's going to fund my campaign, who can I get to contribute, what are the voters going to think, and they do have the freedom to say, look, I'm here, I'm not going anywhere, I'm just going to do the right thing. Does that sometimes mean that that goes to certain judges' head? Sure, it can do that. But the way I see it is, I think I like the fact that we've got a mix. We've got the state courts, which are closer to the people, where the judges have to go out every 6 years and meet the voters and talk to the voters. But we've also got a system that's a little more removed. The federal system, I would be very reticent about getting rid of lifetime tenure. It's something the founding fathers came up with. It's been in the Constitution since the beginning. And it has, yes, it can have some negative impacts, but I think it's helpful that we have these two different types of systems. What's more likely to, if you don't mind, what's more likely to come up is occasionally we get efforts, at least here in Ohio, where you get people saying, let's stop electing judges and let's come up with some other system. Usually they don't come up with a system like the federal system. Usually what they do is they say, well, let's have a commission that chooses judges. I have a lot of concerns about that. But that's sometimes an effort you see, because that's something that, if you were for it, would be doable. Just like you put an issue on the ballot, like issue 1, to amend the state constitution, it could be done. To amend the United States Constitution to get rid of lifetime tenure is a huge process.
What is the possibility and the probability of impeachment, especially with the higher court ones?
It's very rare. I mean, the Senate or the House does have the ability to impeach judges, and then the Senate the power to remove those judges who've been impeached, just like works with the president. I don't remember when the last time a federal judge was impeached. So it's happened.
Didn't I hear in the Kavanaugh that it was in 1885 that the last judge was impeached?
I don't know. That might have been a Supreme Court or Court of Appeals judge.
Yeah.
I know there's, for example, there's a congressman from Georgia who used to be a federal judge, and he was impeached in the 70s or 80s. So, it's happened more recently, at least with regard to the district courts.
Other questions? Right here.
Lou, the president's we have right now, and other presidents have made a strong effort to rein in the powers of some of the executive bureaus. And at the same time, this present president is trying to appoint judges, or to get judges in there who are going to be more constructionist based and limit executive orders, which are really a form of executive bureau acting. I wonder how those two things are going to play out against each other.
I just want to make sure I understand the question. You're saying on the one hand, we've got judges being nominated who are intent on, or at least perceived as being intent on reining in executive action. But on the other hand, what was the other hand?
Well, the judges being appointed who are trying to limit the powers of executive bureaus. At the same time, we're having presidents who like the power of executive orders, and that's another form, if you will, of a bureau acting out of the executive branch.
It is. It's a really good question. It's one that was, I think, highlighted today by his statement about the executive order he may issue. And I could see a real clash in the federal courts over that particular issue. It just depends on the case, though, how these judges are going to come out.
My name is Barb. This is about the Ohio Constitution. I don't know much about, I guess, enough, or I wouldn't be asking this question, but it seems like every 2 years we have these issues which are always going to change the Constitution, and it doesn't appear that other states have quite that easy of a process to change your Constitution. Is that accurate or not?
That is accurate. I mean, there are other states like Ohio where voters can change their state constitution through a simple majority vote, or at least I think we're not the only one where it's a simple majority. In some states, it requires a higher percentage, a supermajority. And in some states, voters cannot, at least they can't do it through a simple vote. Some states don't even have referenda. In Ohio, we can amend our state constitution. The voters can. We can amend our state constitution, or we can pass legislation. Both happen in Ohio. In some states, neither of those are permitted. California is a state where, like Ohio, we have a lot of activity. They have a lot of activity in that regard. Can I make a quick detour and mention something to you? I'll make a book recommendation. When you think about the Ohio Constitution, I'm glad you mentioned it, because the vast majority of people, I think, don't even know that states have their own constitutions separate from the U.S. Constitution, but they do. The states are political bodies that exist separately and independently from the federal government, and they have their own constitutions. There is a great book you all should read. Judge Jeff Sutton, who's a judge on the Sixth Circuit, he lives in Columbus. He wrote a book this year called 51 Imperfect Solutions, Imperfect. And it's a book about state constitutional law. Judge Sutton has for probably 20 years been a kind of voice in the wilderness telling people about the importance of state constitutions. And he finally, he's written lots of legal scholarly articles, but he finally wrote this book kind of for the average person to understand what state constitutions are, why they're important, and why courts and citizens should take them importantly. One of his big arguments is the state constitution isn't the U.S. Constitution, so it could be interpreted differently, particularly when the language is different. And one of the examples he gives is, or at least I think it's one he gives, maybe one I've given, but regardless, same idea. I should explain, I had him for class when I was in law school, so some of this kind of runs together. But the U.S. Constitution, First Amendment, Congress shall make no law regarding or limiting the free exercise of religion, and you've got the Religious Liberty Clause and the Free Exercise Clause. But it's just, it's one sentence, and it includes speech and freedom of assembly and all those other things. But the Ohio Constitution, the section on religious liberty, is a paragraph. I mean, it's probably 100 words at least, and it goes into things like freedom of conscience, and there's other phrases that are used that are not in the U.S. Constitution. And so the argument is the state constitution may provide rights that aren't recognized by the U.S. Constitution. And so courts ought to take those differences in language seriously, because different language has different meanings and should have a different impact. So I recommend looking into that.
We'll add a copy to the library for any of you. That sounds like a fascinating book. We only have time for one more quick question. In the back, Carl.
Yes, my name is Carl, and my question is, how many more vacancies do you think are going to occur in the U.S. Supreme Court over the next couple of years? It's no secret that Justice Ginsburg is up in years and she's not in the best of health. Someone was saying that they also thought that there was another member of the court that might be in the same category.
I have no idea. I mean, I don't think anybody does except those 9 individuals. Could she resign? I guess. I mean, I don't think it's likely. I think she's likely to want a different president to be in office before she resigns. Could another one resign? Yeah, I mean, yeah, you could even, I'd hate to see it, but I mean, you could see Justice Thomas resign and say, you know, I'm going to resign while Trump's in office, or, you know, somebody else. You just don't know. That's a, you know, that's like the number one legal parlor game, I guess, guessing, you know, what will happen with the Supreme Court. And I have no idea. It's not worth anything, but I wouldn't be surprised if at some point, especially if President Trump's reelected, we have at least one more vacancy, but we'll just have to wait and see.
Just a really fascinating class tonight. Let's thank our speaker. Thank you so much.
Thank you.
Really enjoyed it. And where can people read your writings at, Matt?
I don't write that much other than on social media, and I do occasionally publish an article here and there. But there's no like blog or someplace like that you can go to. I would recommend, even though I'm not here, even though I'm not speaking for the Federalist Society tonight, there is a lot of great material that the Federalist Society has available on its website. So if you're interested in legal issues, I would recommend that site.
Let's give him one more round of applause. Thank you so much. Thank you for coming tonight. We'll hope to see you at some of our next events. Have a great night, everybody. Thank you.